looks like Mr. Zandy, I received a notice of appearance that he's representing Mr. Eric Francis. And I'll ask if Darcy Francis is on the line. Ms. Francis, are you on the line? So I can see an individual named Darcy Francis, and at least that's the name, but I'm not sure. It looks like she can't hear me. Ms. Francis, can you hear me? I'm just going to send a quick note in the chat. Mr. Zandy, are you able to hear me?
I can hear you, Judge. Yes, I can.
Let's see. And I saw your mouth move, but I didn't hear anything. So maybe I need to do something here on my end. Okay, let me try that again, Mr. Zandy.
Yes, I can hear you.
Okay, good. Helps if I unmute my mic or my speaker. So let's see, Ms. Francis, can you hear me?
Okay, yeah.
All right, very good, great. Okay, so we're hearing the cause of Darcy Francis and Eric Francis. It's on today for two motions: a motion for temporary orders relating to parenting plan and child support, and also a temporary restraining order. So I've reviewed those documents. I received some proposed orders from Ms. Francis, and then I just received this morning a notice of appearance from Mr. Zandy that he's coming on to represent Mr. Eric Francis. So just a friendly reminder to Diana Galley, if you could mute your phone, please. Okay, thanks. So as far as proceedings today, it looks like I didn't see service of the parenting plan and child support of Ms. Francis. I didn't see that you had served Mr. Francis. So we're not in a position to hear that particular motion today. And then I just wanted to get Mr. Zandy's take on what he thinks the case should happen, or what should happen with the case today with his coming on. And then we'll hear from Ms. Francis what her take is with Mr. Zandy coming on.
I appreciate that, Judge. Yes, the court's where I do and have very recently put in my notice of appearance for Mr. Francis. It's our position to try to piece this together in a very short amount of time. I was consulted with my client earlier this week. He retained formally, I believe it was either Tuesday or yesterday. We put in our notice of appearance right away, and here we are. I have had the opportunity to look through this in my limited time. It appears to me, and of course, Ms. Francis can correct me if I'm wrong, that my client was served on July 21st, which is less than 2 weeks ago, with the emergency restraining order, as well as the docket notice for today's date and the motion accompanying that order. So on that end, we're on for two things. Today's the temporary orders on the dissolution. It's also the restraining order. I would kind of submit that it makes the most amount of sense to hear everything together, to consolidate both hearings. Given that the notice was improper, not timely served on the restraining order, I think it probably makes the most amount of sense just to kind of hold on, keep things where they are for the time being, put this on a regular domestic docket, and now that attorneys involved, and it looks like this would be a odd number case. I don't know if that's yours or if that's Judge Fassett's, but put it on either one of those and proceed and consolidate, have everything done at the same time in 2 weeks or so.
Okay. Yeah, I think it would be Judge Fassett's. Okay, thank you, Mr. Zandy. All right, so Ms. Francis, so what I saw that it looks like you had served the temporary restraining order on Mr. Francis on July 21st. Does that sound right?
Yes.
Okay, and so there's a longer period of notice that parties receive once you serve somebody. Then they have there's a longer period of time than the 12 days. So there's not enough time for them to respond, and so the request from Mr. Zandy is to set this matter over to the 15th of August at 1 p.m. Have everything heard at that time, and I'm leaning towards continuing that temporary restraining order until we have that hearing on the 15th. So that's kind of where I'm leaning at this point. Ms. Francis, do you have what are your thoughts?
He didn't make me aware of not having an attorney. I thought they were supposed to, and I thought I was supposed to get an option to do 1 and 2.
Yeah, it looks like Mr. Zandy, you probably haven't received it yet. It looks like his office sent out a proof of service to you yesterday. So that looks like that'll be in the mail shortly.
I don't feel like that was very fair to be shock and awe. Also, yeah, the restraining order was because he was obviously, he drinks a lot, and he was harassing me and the kids, and nobody could walk around the house with this man. So, and when they served him, he was drunk as well. So I don't really, I don't know what else to do, I guess, at this point. I just, but listen, so.
Okay. All right. Mr. Zandy, so you heard my plan as far as setting all matters to the 15th at 1 p.m. and continuing the temporary restraining order until that time.
Yeah, and I think that makes good sense. I don't have any objection to that. I know from my client's perspective, his goal is just to have time with his kids. He misses his kids. I'm sure they miss him as well. So if we set it, I think the 15th is a good date. That gives us time to file the responsive pleadings and get an answer out, and also, I guess lessens the amount of time that he goes without seeing his kids.
Okay.
I not put that he needs 30 days treatment in that restraining order?
You may have asked for that. I don't know if in the order that was granted by the judge, if the judge granted that. Let me double check. I don't remember seeing that, so let me just review that.
He's an alcoholic. He drinks and drives.
So let me just take a moment and review the order. So I don't see that in the temporary order that was issued. So that's something that you can certainly address on the 15th of August. But until that time, what I'll do, the order that was entered on the 12th of July, I'll continue that until August 15th when we hear the case again. Okay. So Ms. Ransom,
ma'am, if you do, I apologize, Judge. Ma'am, if you do have any questions or serve anything, just please give that to my office. You should get my notice of appearance in the mail today. And if you do are agreeable to Eric seeing the kids in any capacity between now and the 15th, please let me know.
They don't want to see him.
So you all can talk about that a little bit more once we're offline. But so Ms. Francis, just confirming for August 15th at 1 p.m. that works well with your schedule.
Which the 15th at 1 p.m.
Yes, ma'am. That's a Tuesday.
Okay.
Okay. All right. Great. We will see everybody on that date and time.
All right. Thank you.
Thank you, Your Honor.
Your Honor, this is Beth Fellows, guardian ad litem.
Good morning.
Good morning. If we could take the Wade Harlan matter, it will take all of about 2 seconds.
Okay. Yeah, I'm fine with that. So this is Cody Wade and Lacey Harlan. Fellows is here as the guardian ad litem. I'll see if Cody Wade or Lacey Harlan are here. If you are, please speak up and let us know you're here.
I don't believe that they will be. This was a review of the payment for the GAL fees. I would like to actually apologize to the court, although it was not in front of Your Honor. We were here last week and I was having technical difficulties. I could not log on. So it was Commissioner Chelsea Baldwin who sent it over to this docket. But this really needs to be stricken because way back, I think in June, when I questioned whether or not the GAL fees were paid, I was mistaken. They were paid in full by both parents. So this matter is done, dealt with.
Great. That does make for a short hearing. So we'll just put that in the court minutes that the GAL fee has been paid, and we'll just strike today's hearing.
Yes, thank you, Your Honor.
So thanks for that update. I appreciate it.
Yes, sir.
Okay, welcome to you. And then Mr. John Miranda, can you hear me?
Yes, sir, I can.
All right, welcome to you also. This is a motion for contempt brought by Ms. Wanzer related to medical expenses in Florida and also expenses related to travel for graduation of Hope. So I wanted to, before we get started, I wanted to ask Ms. Wanzer about the service. So let's just kind of just look at that first, because I had a question about that. Let me pull up the documents. And when I refer to service, I'm referring to the documents that Ms. Wanzer's filed and that were given to Mr. Miranda. So on, let's see, June 29th, it looks like John Miranda was served with documents, and it says contempt hearing documents, and then it was signed by Marlene Wanzer. So question for you, Ms. Wanzer, it was not clear to me which documents were given to Mr. Miranda.
Your Honor, I mailed all the documents to him because he lives in Florida. And then I did a service to the post office, and then I turned in the receipts, and then I returned that I got a signature card and that they had signed that they had received the service. And so I turned those in.
So you submitted the return receipt, like the
Yes.
signed returned receipt. When did you turn that into the clerk's office?
I believe it was last week.
Okay, so I'm not seeing that. Let me check with Mr. Miranda. Mr. Miranda, did you receive documents from Ms. Wanzer related to the contempt?
I did. I got a motion for contempt hearing packet, FL all family 165.
Okay. And did you receive an order to show cause? The two-page document.
All I got is the filed Superior Court clerk order to go to court for contempt hearing and the motion for contempt hearing.
Okay, yeah, I think that's what we're looking at. So let me touch base with Mr. Miranda. There's two ways to approach this. One, it's unclear to me from the record what documents Ms. Wanzer filed or gave to you. I've heard what you've said. So technically it's deficient. Also, she was the one that mailed it. The party that they themselves can't mail it. There has to be a third party. So we could come back and address this at another day and she can redo all those documents and steps, or you can waive those procedural rights and proceed today. Do you have a preference?
Your Honor, I wish to proceed today so we can be done with this.
Okay. All right. Very good. Okay. So noting that Mr. Miranda waives the deficiencies in service, we'll move forward with the hearing. So I'll hear first from Ms. Wanzer and then from Mr. Miranda. Just so you're aware, I did read the material submitted by Ms. Wanzer, and I did read the response by Mr. Miranda. So Ms. Wanzer, if you want to go ahead and just state your reasons why you think contempt is appropriate.
Sure, Your Honor. Just that they moved to Florida and that John had made some pretty big promises to hope to get her to move to Florida with him. She did not really want to go. He has, assured the Ann Height that, he would pay for her round trips to come home for vacations, which did not happen, and was found in contempt for March when she came home because he did not pay. And moving forward, going to graduation, I had asked that, Hope, pick us up, as she had a broken car. And so I said, well, can you have your dad? I don't have the money to rent cars. He made it nothing but harder for me to come. I'm on a very limited income. I'm on permanent disability. And he had stated that he would help me any way possible in accommodating me to come to Florida if I come to see her round trip. So that was that one. And I only put in for 50% of what I paid. I just thought that was fair. And also,
could I ask you a question on that, Ms. Wanzer?
Sure.
Related to your travel expenses to Florida, is there a court order that requires Mr. Miranda to pay for a rental car for travel expenses?
No, it was just stated that it was kind of a open statement there that he would just help me with accommodations when I came, if I were to come round trip.
Okay. All right. Thanks. And then why don't you tell me about the medical expenses?
The medical expenses, she's on his insurance and she got very sick a week before graduation and had to go to the ER. Also, she had, told her dad that she was sick and he was just like, whatever. And she called me all day the day that she went, and she just, Mom, I just don't feel well. She got really sick. And then I said, well, make a doctor's appointment for tomorrow. By the end of the evening, she couldn't bear it. And I said, well, go to the ER. And so she tried to go to urgent care, and eventually she couldn't. She went to the ER and had to have a procedure. She was very sick and had to have medications for afterwards. Anyways, so this is, like I said, a week before graduation. And then she did ultimately get better. And, then John handed her, of course, the processing with the hospital and everything. So it was after graduation that they got the bill after what insurance paid. And John had handed it to her and says, here you go, kid. Welcome to being an adult. And she called me kind of freaking out. Mom, what do I do? Because, I just graduated. I only work part-time. And, how am I supposed to pay this? It's over $1,000, I believe. So anyways, I just kind of feel like she was still in school, that he should be taking care of her.
So thank you, Ms. Wanzer. Hope turned 18 on April 4th.
Yes.
And the hospitalization was middle of May, I believe, the 15th.
Middle of May. She was still in high school. Yes.
Okay. And then the temporary child support order, I saw that the child support order related to uninsured medical expenses is dated December 14th of 2012. So that's the document that I'm looking at. Is that the same document you're looking at that relates to uninsured medical expenses?
I'm unaware about any, yeah, I think so. But there was the child support was completely stricken.
I don't see that order of 2012 was ever stricken. So it's still in effect.
All I know is that there was never any child support. John had waived it. We had decided together that we had waived it. Also,
is there an order that says that child support was waived?
No, we did it privately.
Okay. All right.
With support enforcement.
Okay. All right. And then let me ask you, looking at that temporary child support order from December of 2012, it says that there's a division of responsibility, that Ms. Wanzer would pay 31% and Mr. Miranda would pay 69%. And that order did not necessarily contemplate continuing obligations past the age 18, except for post-secondary education, where it specifically said that provision was reserved for the future. So if my understanding and assuming that order is still in effect, there's not an explicit provision that says that past age 18, the uninsured medical expense is obligatory on both parties. What's your response to that? Can you help me understand your?
Well, my response to that is that she was still in primary, she was still in high school. So if you're going to extend it through secondary school, wouldn't it, doesn't that apply through high school?
Well, the one specific thing that said that was reserved for future ruling would be post-secondary support, post-secondary schooling. So that was reserved. So there's no explicit mention of it at that time. So the other question is the billing statement that you submitted that lists, the insurance coverage and the amount owing says the responsible party is Hope Miranda. What's your comment on that?
Because she, of course, was the patient, so they sent it to her.
Okay.
It's under John's insurance, of course.
Okay. All right. Very good. What other information do you want to share about your motions for contempt?
Well, just that, that he has stated in the previous court hearing that we had in contempt, that he had made statements that he was didn't pay for Hope's plane ticket because he was providing her with a ticket to come home for the summer for an extended stay, which he hasn't. In fact, I just purchased her a ticket to come home next week. Is
that part of your motion for contempt? I didn't see that.
No, I'm just saying it shows to character of just how I can't count on his word even in paper.
Okay. All right. Thank you, Ms. Wanzer. Mr. Randall, what's your perspective on the two issues? Or I guess the one issue on the medical expenses, because I think the travel graduation expenses, there's no order that requires that. So I'm denying that motion for the contempt of that portion. So the focus is on the medical expenses at this point.
Yes, sir. So I provide insurance. I will continue to provide health insurance for Hope, my daughter, as long as I can keep her covered. But I had told her previously to schedule a doctor's appointment when she had first told me that she was having some pains. I was not like, whatever. I told her to go see our family doctor and schedule an appointment. Hope is a procrastinator and didn't do that immediately. So a day or two after, she had scheduled an appointment after talking with her mom. She never made it to that appointment because she went to the emergency room that evening. I kind of had a conversation with Hope after returning from the emergency room, just letting her know that, the costs are going to be exorbitant because you went to the emergency room. Everything is, it seems like almost double. And I said, if you'd have gone to the doctor's appointment, something may have been able to be done at the doctor's, which would have been relatively cheaper, and the insurance would have covered a good majority of it. Granted, the insurance covered almost more than 90% of the emergency room, so that was great. I didn't think that it was out of question to help my daughter understand the process of going to the emergency room, that a bill comes along with that. I asked her to contact the hospital, let them know the situation that she is in, that she just turned 18. She's still, just about to graduate from high school, in the hopes that maybe they would either waive this or move it to, to a minimal payback. That was my ultimate hope for it, Your Honor. And in asking Hope to take charge of that, it was, she would like to be treated as an adult. And, with the treatment of, asking to be treated like an adult comes this responsibility. So I asked her to take care of it. Next thing I know, I'm being served with papers as far as the contempt hearing here.
Okay, thank you. Let me ask you, if I may. So the temporary child support order of December 2012 indicates that there's a division of responsibility for uninsured medical expenses, a 31-69 split. My question, I guess, is that as the person providing the insurance to the insured, Hope, if there's a remaining balance, the obliger or the party responsible for that is the policyholder, is it not?
I would say that ultimately, yes, they would come after me if Hope didn't pay it. Yes.
Right. Yeah. If Hope decides not to pay it, then they're going to come after you for payment.
That is correct.
So, and this just happened in May, and now we're just barely into August. Okay. Okay. All right. That's helpful. Let me just look at one item here.
Your Honor, when you have a second, I have one more question for you.
I'm ready. Go ahead.
I was just wondering, now that Hope is 18, has graduated high school, and she is working. When is she actually considered an adult, and where does our parenting agreement kind of end when she is considered an adult?
So there's a parenting plan that was issued on September 30th of 2022. And then when a person turns 18, the parenting plan is done. Because she's a person of age of majority at this point. So he's no longer a minor.
Thank you, sir.
All right. Ms. Wanzer, do you have any just brief response?
Not really, Your Honor, just that, I've been on disability now for a few years, and I live on, minimal funds, obviously, because they don't pay very much. So I just feel like, John has taken every advantage that he can of me in the past and still does. So that's just, that's pretty much it.
Okay. All right. Thank you. All right. So there were two grounds on which Ms. Wanzer brought a motion for contempt. The first was the travel expenses to Florida. So any order or any motion for contempt necessarily needs to be based on a court order. And then the allegation needs to be that a person violated or did not follow that court order. So as I mentioned earlier, there was no court order that required Mr. Miranda to make any expenditures related to travel for the graduation trip or what have you. So I'll deny that portion of the contempt. The other portion is that the medical expenses for the emergency room visit. It sounds like she wasn't doing well for a period of time. There was encouragement to take a different action. She got the help that she needed, whether it was timely or maybe a little later than hoped for. And then there's about a $1,100 bill that's outstanding. So the child support and health insurance is a little bit different in that health insurance generally parents can keep their children on their coverage up until about age 25 is pretty common across the country. And here we have Mr. Miranda's indicating that, he's the obliger, he's the contracting party with the insurance company. So eventually they would come after him for the balance. But here there is an existing temporary child support order. It's temporary and it's old, but it's from 2012. It requires Ms. Wanzer to pay child support, but we're not here on that issue. We're here on that says that if there's uninsured medical expenses, then there's a split of 31% and 69%. So there's no clear indication that the child support obligation ends at age 18, because it's often common that children will turn 18 and still be involved in educational pursuits at the secondary level, high school. So here, I think that obligation continues. So both parties are responsible for the $1,049.89 in a calculus of 31% of Ms. Wanzer and 69% of Mr. Miranda. So that's what the parties are obligated to pay the hospital. As far as the contempt, I think there needs to be a willful and bad faith refusal to comply with the court order. So here, the court order is over almost 11 years old. There was in a relatively short period of time from the provision of services until the contempt was filed. There was some question related to age of majority and the like. So I'm going to deny the contempt, but just make clear that the parties are responsible in that percentage division for payment to the hospital for the services rendered to Hope. So I'm denying both motions for contempt. However, both parties kind of have a clear idea of what the responsibility is under the child support order from 2012, that 31% to Ms. Wanzer and 69% to Mr. Miranda. Do the parties have any questions, Ms. Wanzer or Mr. Miranda?
Yeah, Your Honor, actually I do. How am I, I live on $1,000 a month. So paying $300, what am I looking at there?
So that would be something that you could check with the hospital and work out payment arrangements through them. I know a lot of hospitals have charitable causes and they have some flexibility in their payment plans, and they work with people. When people don't reach out to them, that's when they get concerned, I think I've seen in the past, but that would be your responsibility to work out something with the hospital.
Your Honor, Your Honor, if I may, just to bring it up, is Hope gets a stipend of Social Security benefits.
Your Honor,
That should probably
object.
go to that.
No, Your Honor, I object.
So Ms.
Cut
Wanzer,
off.
as a general rule in my courtroom, I allow people to finish, and your objection is denied. There's not a legal basis for the objection. Mr. Mando, you can finish your thought.
Yes, basically what I was saying is Hope gets a stipend from the Social Security that she gets along with food stamps that are provided. I watched this child since she has been getting it because I have nothing to do with it, waste this money. So I think it would be very appropriate for this to go forward to that. I do understand your ruling is I'm obligated for the 69%. And if you rule I'm obligated to that, I will pay that bill to that. But Hope being an adult should have some kind of responsibility towards this.
Okay, thanks. So I won't make a ruling on that. That's something that the parties can work through. I get where the parties are coming from and teaching responsibility and accountability and financial wherewithal. I get that. So I won't rule on that. The parties can figure that out. Ms. Wanzer, any last comments?
Yes, I do want John to know that she was cut off months ago from Social Security.
Okay.
And that was as soon as she was 18. She no longer got any more money.
Okay. All right.
Let's see if.
All right. Thank you both.
Watts, are
That'll
you on the line
conclude
today,
today's
Shanice?
Yes, I am.
All right. Welcome to you, Ms. Watts. And Brandon Lovato, are you on the line today? Brandon Lovato?
Yes, Your Honor.
Okay. Well, welcome to both of you. All right. So let me just double check. This is Ms. Watts' motion for adequate cause to modify a parenting plan. I want to first talk about service. As far as proof of service, I did not see proof of service of the motion papers served upon Mr. Lovato. Ms. Watts, did you provide some type of declaration or statement that you served X, Y, and Z documents to Mr. Lovato on date A, B, or C?
No, so I didn't, but we had spoken. He said that he already knew about the court date and he already had read the paperwork. So and he said he would be here today. So.
Okay. All right. Let me check with you, Mr. Lovato. There's procedural rights for service that require proof of service that says, hey, I, as the moving party, served a number of documents or a document upon the responding party on such and such a date. So you can waive that right to have that done correctly. And then Ms. Watts could reserve things and do that properly, and then we could come back at another time. Or you could waive those procedural rights related to service, and we could hear the matter today. So I don't care which way we go. Either is fine. So do you have a preference?
Yeah, I already paid to get them from the court, so we just move forward today.
Okay. All right. Very good. We'll note that Mr. Lovato is waiving his rights, procedural rights for service for this particular hearing. It looks like he received the information that was necessary. And then having resolved that issue, let me check with Mr. Lovato. Mr. Lovato, I read the viewpoint and information from Ms. Watts. Did you submit any documentation for the court to review?
No, because I had my girls for the summer and I just didn't really have much time to. By the time I actually found out about the court date was after it was already scheduled. After it was I think there was a court on the 11th, and I wasn't aware of that, and so I didn't even start getting the paperwork until like about a week and a half ago. And so I just haven't had time, but I did read her complaint.
Okay. All right. Well, so do you feel like you had adequate time to prepare a written response and submit it to the court so your view could be read and digested?
I haven't had time to do a written response now.
Okay. Do you want to provide a written response?
I don't think I'm going to really need one. We've kind of already talked everything out. So, I mean, unless she's trying to keep the original motion.
Okay. Well, let's hear from Ms. Watts. Your motion is for adequate cause related to the parenting plan and the move to Alabama and the like. So I'll hear from you, Ms. Watts, what your vantage point is in relationship to kind of what Mr. Lovato was saying.
Yeah, so when we first did our parenting plan, we did 50-50 in the state of Washington. The girls go to Kelso. So then he gave up his rental here and then moved to Foley to Alabama. And so we couldn't remain doing 50-50 with him living in Alabama. The girls are there right now for the summer. So we were going to they stay here during school and then go there in the summer. Our youngest, Kaylee, she's been having a little bit of like behavioral stuff going on. So we actually talked it out to where we're going to see, because she's been fighting a lot with her sisters and stuff. If she stayed with Brandon for a little bit longer, so the other two would come back before school started, but then Kaylee would stay. She would stay in Alabama for a little bit longer to see if we can see if her behavioral stuff gets a little bit better, I guess. We're just going to do it, like, just see if like it helps her at all. So then we're just going to do that for a couple months and see. And then if she's better, then she will just stay there, and then I'll get her in summer. And if it's not better, then she's going to come back here and then do school here.
Okay. Okay. All right. Thank you. Appreciate that explanation. Mr. Lovato, is that the plan that you and Ms. Watts have agreed upon?
Yes, that's what we agreed upon.
Okay. So let me just go back just kind of procedurally why we're here today, that there's a motion for adequate cause to modify the parenting plan. So that's kind of step one. Step two would be the actual modification of the parenting plan, which it sounds like the parties have pretty much agreed upon. So I'm inclined to grant the motion for adequate cause because there's been a substantial change in the position of the parties based on the move to Alabama, which makes the 50-50 parenting plan impractical. So I'm in a position to approve that order for adequate cause. And then the next step is the actual modification of the parenting plan that I don't know if the parties have drafted a parenting plan that reflects your agreement that talks about, school, the children would be with Ms. Watts, and during the summer they'd be with Mr. Lovato, and with kind of the nuanced with the one child and staying a little bit longer with dad.
Yeah, so we haven't done that yet because we just recently started talking about it. So I think we will have to submit a new one just with the new changes and stuff, with Kaylee staying there a little bit longer and evaluating her behavior and whatnot.
Okay. Let me ask the parties if I can submit the order on adequate cause and get that filed. And then I think it would be helpful, and you can tell me otherwise if it's not, to set a date, maybe in a month or so, or 6 weeks, to allow the parties to work on an order that reflects your agreement. And then we could come on that date. And if you've already submitted it, then it would be signed off on if both parties have signed it. If both parties have not agreed on that revised parenting plan, then we would be here in 4 to 6 weeks to address the issue and figure it out. So
Yeah,
what do you think about that?
Well, the only issue, Your Honor, is in order for me to have the youngest registered for school down here, I'll need to have paperwork showing that she's living with me with the court, because the current parenting plan would show her living in Washington, and I wouldn't be able to register.
Gotcha. So you're maybe looking at more of a expedited time frame.
Yes.
When does school start for the kids there in Alabama?
It starts on the 12th of August.
Oh, that's soon.
Yes,
Oh.
very soon.
So we have one more date, which would basically be in a week, which we could come back and hopefully the parties have kind of hashed out and worked through the parenting plan. And then if there's any fine details, then we could probably address those on next week's docket. Ms. Watts, how does that look for you?
Yeah, that works. The only other thing that I had questions about is the last time we went to court about the girls' Social Security, it was supposed to be in a joint account for both of us to be able to pull from. That still hasn't been worked out since he moved to Alabama. So is there a way that we can get that worked out too?
So yeah, let's pause on the Social Security thing just for 1 second. Let me just confirm with Mr. Lovato if you're available next week, the 10th at 9 a.m.
Yes, I will be available.
Okay. Then the question raised by Ms. Watts, you said at the last hearing, which was back in March,
Yes.
that there was some type of agreement related to Social Security, correct?
Yes.
Yes, the girls' Social Security was supposed to be put into a joint account that me and Shanice held together.
Okay. And is that in place? Is that happening?
No, there was things that happened right before we were going to create the account, and so it made it not necessary. But turned out to be necessary in the end after all. So.
Yeah, Your Honor, because after he moved to Alabama, he kind of was playing games with the money. Because since I had them full time, we agreed that he was going to just give me all of it since he didn't even have the kids at all. And it kind of was a struggle to even get it all from him at times. So I just want to make sure that I don't have to go through him to even be able to get the girls this money.
So where's the money now?
It goes straight into his account.
Okay. And you wanted to to have it to go into a joint account.
Correct, yes.
Okay, so I'm just reviewing the minutes from March 30th. So it says court questions regarding Social Security benefits. Mr. Lovato responds, suggests joint account. Ms. Lovato responds regarding paying for the all oldest child and half of other children. Court addresses the party regarding deviation, residential credit. Goes on, talks about TANF. Then the court orders transfer payment. Says court orders joint account be set up for each child for the Social Security benefit. That I'm not sure if that was reduced to a court order, that portion of it. You know, there's the verbal order and then there's the reduction to paper. And I'm not, do either party know if that was reduced to writing?
It was never put in the actual order itself, no.
Okay. Do you agree with that, Ms. Watts?
Yes.
Okay. So often what happens, the court relies heavily upon the parties or attorneys to draft orders due to just sheer number of cases coming through. So if that was not done, that could be done now and retroactive to March 30th, basically just a memorialization of that order. Does either party have any concerns related to that?
No.
No, Your Honor.
Okay. So let me just put this here. Just give me just a moment to jot this down. And the joint account would be between Ms. Watts and Mr. Lovato, correct?
Yes.
All right.
So since I will have our two full-time, because when we first initially did our child support order or whatever, I had Courtney full-time, and then the other two would do 50, like half on, half, or week on, week off with myself and Brandon. Since he had moved to, now he lives in Alabama, I now will have Courtney and my middle child Bailey full-time, and then them go there for the summer, and then Kaylee will be with him full-time until we figure out her situation.
Right.
So as far as that, because he pays $400 for just Courtney since I have her full-time, but now that I have Bailey full-time, do I need to because I don't think it would be fair to have him also share that there goes Social Security and be able to touch them when I have them full-time.
So that sounds like that maybe requires some type of specific motion requesting the relief based on the change that has occurred. Your motion today for adequate cause addresses the parenting plan. Obviously, parenting plans can affect child support. The child support issue is not ripe because we don't have financial information from either party, any proposed worksheets, proposed orders. We don't have any of that. So that may be something that a continued or additional motion would be necessary to address that. And then all the parties can supply the information. That's probably not going to happen by next week, but that would be something that the parties, if you want to talk about that, you can certainly talk about it and come to an agreement. If you can't come to an agreement, then a motion can be brought by either party to address it.
Okay, sounds good.
Okay, so what I'm going to do, I'm going to submit and sign an adequate cause order making a finding that there is a substantial change, a major substantial change, and that then there will also draft an order related to the joint account that it needs to be established for each child to receive and access Social Security benefits. And then we're setting this matter over to the 10th at 9 a.m. for submission of the parenting plan. That's what I know. Do the parties have any questions?
No, Your Honor.
No.
Okay, I'll make sure that both of those orders are drafted and submitted today, and you can access them. And then we'll see each other on the 10th at 9 a.m. Maybe a different judicial officer, but the hope is that the parties can hammer out that parenting plan with the new details and the new situation. And if not, if there's the finer points that you can't come to agreement, then that could be addressed at the next hearing. If you can address everything, fantastic. You can submit it signed by both parties, and then we can go from there. It would be nice if once you've drafted that parenting plan, to submit it to the court so the court can look at it, what areas there are of agreement, and if there are any areas of disagreement, then the court would at least be apprised of what the issues are. So if you can get that far in your progress, that'd be fantastic, and hopefully we can have this resolved. She's present, and I'll ask if Justin Yokel, if you're on the line, please state your name.
Justin Yokel.
Right, welcome to you, Mr. Yokel. And Courtney Geyer, if you're on the line, please state your name.
Courtney Geyer.
Okay, well, welcome to you, Ms. Geyer. All right, we're here for a review of the Ms. Turnbull's report, which was submitted on July 17th, 2023, then made some recommendations. I'll ask Ms. Turnbull, do you have any comments related to your report that you submitted?
Not at this time.
Okay, all right, and then let me hear from the parties what your take is on the guardian ad litem's recommendation related to the parenting plan of Talon. So I'll hear from the petitioner, Mr. Yokel, first, and I'll hear from the respondent, Ms. Geyer, next. Mr. Yokel.
There was a few things on there that I didn't agree with or thought that it gave the whole spectrum of what's been going on. And yeah, I just obviously I want to be involved more with my son, so I didn't agree. No.
Okay, maybe I can just kind of walk through the recommendations and then you can give me your take on it. So first recommendation is that primary custody be granted to Ms. Geyer and that you would have visitation. What's your take on that?
I don't necessarily contest that. I just I guess I'm more about the supervised visits. I don't think that it a lot of the stuff that was talked about was kind of issues between me and his mom, from the past. Like I said, I just Talon's my number one concern. I'm not saying that I wouldn't do anything, because I would do anything for him, and if it requires me to do that, that's what I'm going to do. But I just want what's best for him, and I just want everything to just to be as normal as it can be, and just get through this is what I'm hoping.
Okay. All right. So your main concern is the supervised visitation recommendation. You indicated that if that has to be, then fine, you'll do it because your relationship with Talon is really important. But if you had your druthers, you would have it be different and would not be supervised, correct?
Yes, sir, Your Honor.
Okay. And then there was recommendations for mental health evaluation and SUD evaluation and any follow-up treatment. What are your takes on those?
I mean, I have no problem. I could UA today. And as far as mental health, I mean, it couldn't hurt. I don't, I'd like to have some counseling, with my son if possible, or just, I mean, whatever can help, I'm for. I'm not, against anything that's gonna, benefit me or him. So.
Okay.
Yeah.
All right. So okay. So with SUD evaluation, you're okay with doing that, and then the mental health evaluation, your indication is that your focus is to build a better relationship with your child, and so it couldn't hurt, and so you'd be open to doing that.
Yeah, and what exactly is the SUD?
Yeah, and substance use disorder evaluation. Basically,
Okay.
if there's any concerns related to substances and getting away of life and the like, then they would do an evaluation. And what the evaluator determines is appropriate, then that would be the recommendation for treatment. And the treatment may be none, or the treatment may be take an 8-hour class, or it could be, take intensive outpatient. I mean, it could, or say, if things are really bad, it could be inpatient treatment, so depends on the evaluator, and they take in information from a lot of different parties. They talk to you, get your take on things, and then they come up with a recommendation.
Okay. Yeah.
Okay. All right. Okay. I appreciate your input, Mr. Yokel. Ms. Geyer, what's your input related to the guardian ad litem report and recommendations?
Yeah, I agree with the guardian ad litem's report.
Okay.
I know there was some say that he was clean off heroin for 2 years. I want to bring up that I have been concerned since heroin, it went to fentanyl. I'm very concerned for my son to be around or come across that after hearing how deadly it can be.
Mm-hmm.
So that is my high concern.
Okay. All right. Thank you, Ms. Geyer. Ms. Turnbull, do you have any comments?
Yeah, I wasn't aware of that concern until just recently, after I concluded my report. But if that is a concern, I would agree that that's, of course, that could be very deadly very quickly. And I certainly wouldn't want Talon around that.
Okay. Thank you. Yeah, and I think Mr. Yokel indicated that he's willing to do that SUD treatment and evaluation. And if there's concerns related to fentanyl, obviously fentanyl is an absolutely terrifying drug because of its impacts to the living, and it causes a lot of overdose death. We just lost a client in drug court just last weekend, and it's rampant. It's an absolute scourge. And so if there's any concerns related to that, hopefully that they're not, and if there are, then that could be addressed by the SUD evaluation and the like. So yeah, I think everybody kind of shares in that concern, including Mr. Yokel, because everybody wants Talon to be fine and safe and well. Okay. All right.
I also have one more question.
Yeah, go ahead.
I have this restraining order in place, and just like 2 days ago, he texted me asking, "Hey Dad, hey Talon, it's Dad, just trying to get a hold of you." He's not writing my name, but he's writing my phone. What are I guess I need guidelines, or I don't, unclear. Like, I thought he was not supposed to be writing me. So reaching out for Talon even on my phone, that's still not okay, right?
So when was the order entered? Do you remember?
For the restraining order, I don't. I'm at work. I don't have it with me.
Mr. Yokel, do you remember the approximate time frame?
It was I'd say about a month ago, maybe.
About a month. Okay. Let's see.
I have I wasn't trying to contact her at all. I don't have any I didn't know how to reach my son. I haven't talked to him for a while. He's used to seeing me, and it's been kind of hard not seeing him. So
Sure. Let me ask Ms. Turnbull, I don't recall specifically if you had any recommendations related to that aspect of as far as communication concerning the child. Did you make any recommendations on that?
I would recommend it be supervised for some period of time, because there has been a history of inappropriate involvement of adult issues, that Talon's been involved in, and I am concerned about that.
Okay, so as far as if there was a need as far as communication regarding the child, setting up times for visitations and the like, are you suggesting, Ms. Turnbull, that there'd be an exception, or that there would be a third party that would be the communicator?
For supervised visitation, I would recommend professionally supervised visitation, at least for some period of time, so that we can have some feedback from the professional supervisor as to the nature of the communication between the parent and the child. And
more to the point, as far as setting up, okay, it's going to be Tuesday at 4 p.m. How does the communication between the parties happen? Is it through a third party, or with that restraining order in place? How does that work?
Oh, yes, a third party.
Okay.
Yeah, I prefer a third party as well.
Okay. All right. Ms. Geyer, does that address your concern? Basically, it'd be, if there's a restraining order in place, that needs to be obeyed. And if there's communication involving the child, then if Mr. Yokel needed to communicate with you regarding the child, then he could ask a third party to communicate with you solely on the issue of the well-being of the child.
Yes, the third party is fine with me. I think I put in there something about the app I heard about you guys having that, but obviously there's the restraining order. But regarding Talon, once if there was an app or something you guys had that, with the Wizard, is that what it's called?
Yeah, there's a variety of them. There's one called Talking Parents. There's another called Our Family Wizard, and it's basically an app-based subscription service where the parties can communicate. Everything's recorded, and so you communicate with the children about the child. You can send information, take a snapshot of a doctor's report or a school report and share that information, and everything's recorded. And so it's a really good tool because it keeps everybody just honest and straightforward. There is a cost. I'm not exactly sure. There's an initial kind of setup fee. I think it's like $30, $25. And then there's a monthly fee of maybe $6 or $7. Ms. Turnbull may know better than I, but that's kind of what I remember. So that's there wasn't a specific recommendation of that. Let me just ask Mr. Yokel what your thoughts are about that type of communication tool.
Yeah, as long as I don't have to talk with her, I'm all for it. My main concern is Talon, and yeah, that's just that's why I'm here.
Okay. All right. Thanks.
Maybe that's something we could add in, once we get a few supervised visits under our belt.
Yeah, I think that's probably a suggestion well taken. Okay, so it sounds like, from hearing from Mr. Yokel and Ms. Geyer and Ms. Turnbull, there's no strong opposition to the recommendation that Ms. Geyer serve as the primary custodial parent. So I'll name her as such, as the primary custodial parent of Talon. There's disagreement here between the parties from Mr. Yokel and Ms. Geyer and Ms. Turnbull related to what visitation should look like and whether it should be supervised. I think, based on the information contained in the report and from collateral sources, there's positive and negative, on both sides. I do think that the recommendation for supervised visitation, at least for a period of time, is well taken. That doesn't mean that it's going to last forever. On the contrary, what the hope is that those supervised visitations will occur. They'll go super great. And that once those have occurred for a few weeks or a month or 2 months, what have you, then Mr. Yokel could come back to court and say, hey, things are going awesome. Look at these notes from the supervisor. I would like to move to unsupervised visitation. And so I think there's enough concerns initially that we need to have kind of that proving period or proving ground for a bit. And then we could move to look at doing something different. So I'm going to adopt that. I'm going to adopt the supervised, professionally supervised visitation for up to 4 hours weekly. And then the visitation supervisor will take notes, and those notes will need to be submitted and sent. Mr. Yokel, that you'll be in charge of that. If you could please get those notes, and then you'd file it with the court, and then send a copy to Ms. Geyer. So that will occur, and then it doesn't sound like there's any disagreement with the recommendation for the mental health evaluation and the SUD evaluation, and any recommended treatment for both. I think that would be a help and a support for the relationship and for Talon. So I'll adopt those. And then regarding the communication with each other, with the existence of a restraining order, I think it's important that there be opportunities for the parties to communicate related to Talon, but not directly. So it sounds like everyone's okay with the third party being the kind of the go-between, Mr. Yokel and Ms. Geyer. So I'll carve out that exception in the parenting plan. In the future, when we come back, we could certainly address one of those parenting apps that allows the parties to communicate. So if you want to look at that in the meantime, you can pull that up and just do a quick web search, and you can find a variety of different ones. But the ones I'm familiar with are Our Family Wizard and Talking Parents. You can take a look at that. So that's what I'll adopt at this point. Primary custody with Ms. Geyer, visitation for Mr. Yokel on a weekly basis, up to 4 hours weekly, professionally supervised. And then Mr. Yokel, if you'll please make sure that you get those visitation notes and to the court and to Ms. Geyer in support of your motion. I assume your forthcoming motion for unsupervised visitation, the mental health evaluation. If you need some assistance of where to do that or where to find resources, Ms. Turnbull, do you have some suggestions of where he could turn to find that information?
Yes, I can reach out to him off docket.
Okay, great.
And do that. Yeah.
All right, great. And then the same thing with the SUD evaluation and any recommended treatment. Thank you for doing that. And then once there's been a good period of good visits under the belt, then Mr. Yokel, you're free to bring a motion to modify that plan of visitation and to make a motion to whatever you think would be appropriate as far as the safety and best interest of Talon and your relationship with him.
Yes, Your Honor. I just have one question. When does the supervised visit start, and where do I go? That's
important. Thank you. The supervised visitations, they can start this coming Monday. And then as far as finding a professional supervisor, you can do a Google search. Ms. Turnbull may know of some resources here locally. And then would you be willing to provide those to Mr. Yokel?
Absolutely. Yes.
Oh, so I got to hire somebody then, you mean?
It has to be professionally supervised for the first little bit, correct? And that's why I said up to 4 hours, because I think professional super, it's going to cost a whole grundle of money to do 4 hours in a week. It may not be that amount. What is important, I think, is that the quality of the visits, not necessarily the quantity, but but I'll allow it up to that amount. And so we're looking for a good showing of good visits during that time period, and then we can take a look at removing that requirement.
Thank you.
All right. Well,
Yeah.
Yes, Ms. Geyer, go ahead.
I just had a question. I know I turned in a financial docket months ago when it was, I believe, requested in email, and I don't know anything about child support or any of that. I haven't heard of anything, or is there a step I need to do?
Yeah,
How do I go about it?
Yeah, if any party is interested in child support, any party can bring a motion related to child support. So if one party is seeking child support or wants to pay child support, any party can bring a motion, file and with the court a motion, serve the other party, get it on the docket, and that matter could be heard.
Okay, so the financial docket wasn't what you guys are looking for. That was just something you guys needed instead.
Financial dockets are important in understanding what the financial condition of each party is. So we need financial declarations. Any party that's seeking child support can update their own information. And if they have information about the other party's income, they could update that also. So each party will be under, if that motion is brought forward for child support, then each party would have the duty to supply information to the court related to their finances.
Okay, thanks, Your Honor.
Okay. All right, let me touch base with the parties. If there's any further questions or clarifications, Mr. Yoko, do you have any questions or clarifications?
No.
Okay, Ms. Geyer, any further questions or clarifications?
No.
Okay, and Ms. Turnbull, any final questions or clarifications?
My question is, the order appointing discharges me when I enter my final report. What is your position on whether you want me to stay a part of this case?
We will likely have a review here in the future. Having some of the background that you've absorbed, I think, would be helpful, especially at that next hearing when we make a decision related to possibly moving from supervised or unsupervised. So,
okay.
So if that order says that you're discharged upon submission of your final report, which you've done, then you're telling me that you probably need a separate order of continuation of appointment?
Something like that, yeah.
Okay, I'll craft something, continuation of appointment regarding supervised visitation. Okay, all right, so I'll do that, and I'll get that one out also. Thank you.
Okay, thank you.
All right, and then Mr. Yoko, just be aware that that to address the issue of the supervised visitation, to make it unsupervised visitation, I'm going to rely upon you to file a motion or get the case on a docket so we can address that. So that's going to be your responsibility, and just want to make sure you're aware of that, because sometimes people say, well, the judge said we're going to review it and nothing's happened. So you're going to be the one that takes the ball and drives on that one and to get it moving.
So how many visits do I need to do then?
Yeah, good question. It's up to 4 hours weekly. That could be divided up in any manner of ways. It could be 1 hour, 4 times a week. It could be twice, 2 hours a week. It could be one.
No, I understand that. Like for how long until I can request for to be reviewed?
My thought would be 8 weeks.
8 weeks, 2 months?
2 months.
Okay.
All right. All right. Any other final questions from any party? All right, hearing none, thank you all. If you could just make sure that they're muted unless we're actively discussing your particular case. That reduces a lot of the ambient noise, so I appreciate everybody's help with that. I'm going to call a few cases that I think will be quick in length. I may be wrong, but let's try it. Here we should have present the following individuals. We should have Ms. Gretchen Vandenberg. Are you here, Ms. Vandenberg?
Yes, I am.
Great, welcome to you.
Thank you.
And then Ms. Farr, are you present? Let's see, she's the, Ms. Farr is the guardian ad litem. Let's see, did somebody say something? Okay, let me just check. Okay, great. All right. So just maybe we can just touch base with Ms. Vandenberg since you're here. We're
Yes.
tracking to see if and when the order from Alaska has arrived and whether it's been received from Alaska. So do you know if that has been?
It is not. I actually took it to the courthouse right after our meeting 2 weeks ago, and then it was lost at the courthouse, and I wasn't able to get it until the first part of this week. So the guardian up there should have received it this morning by 9 a.m. their time, and she's going to take it to the court and do everything that she needs to do. So it's in Alaska. It's on its way to Superior Court, and we now will just have to wait and find out what the process will be on the Alaska end and how long that will take.
When speaking with the guardian up in Alaska, did he or she give you an indication of general timeframes to expect transfer?
She didn't. She doesn't know. Sherry did a really good job of telling her exactly what she needs to do in the email. And she said that she was going to go today. So I'm hoping that she got it and went first thing, and then she'll update me. She can update me after she gets to the court there, and I probably would have a better idea.
Okay, thanks. Ms. Farr, go ahead.
Oh, I was just going to say, and Sherry's on now.
Okay, thanks. Ms. Farr, any input?
I just think maybe we could just set it over for about 3 weeks and then just review at that time where we're at.
That sounds good to me. Ms. Vandenberg, how does that sound to you?
That sounds fine.
Okay, so, all right. So if we look at 3 weeks, 1, 2, 3, that would set us to the 24th of August at 10:30. Does that work for everyone's schedule?
Yes.
Yes.
Perfect. We will set it to August 24th at 10:30 to track the order from Alaska, and then getting a successor guardian appointed here in Washington. And we also have, let's see, there's probably a variety of people that are here. Ms. Farr is present as the guardian ad litem. Lillian Aldrich, are you here?
Oh, this is an adult side.
And Your Honor, I wouldn't expect anyone else. Unfortunately, we noticed late that it wasn't Ms. Baldwin. So I need to put that on her presentation docket, although Mr. Anagnostou has already fulfilled a bunch of conditions. So I probably need to change those orders anyway. And I'm sure Mr. Anagnostou will just sign off on them.
Right.
Okay.
Yeah, if we get to amend the order and delete the judgment because it's been paid, and to be able to get that entered by agreement.
Absolutely.
All right. So let's look at setting that Commissioner Baldwin's presentation docket. If the parties make the tweaks and sign off on it, then we can sign off on it. Then we can strike it from that docket.
Sounds good.
Let me check with Madam Clerk regarding Commissioner Chelsea Baldwin, correct?
That's correct.
As far as that docket, do you know when that docket is? Good. Thanks. So in consultation with Madam Clerk, she indicated that generally her presentation docket is on a Tuesday. However, that changes week to week. And so she advises the court administration when she has availability. So might I suggest that, and this comes from the court clerk, to the parties could note it on and that particular docket. And then I think at that point, if it's noted on, then that docket comes. And if she's there, great. If not, then go from there.
Sounds good, Your Honor. Thank you.
Mallory Smith. Okay, great. Smith, are you on the line? Thank you both.
Morning, Your Honor.
Good morning. There you are. And then we have Ms. Winkles representing Carol Lavender. I know Ms. Winkles is here because I was just talking to her. And is Carol Lavender on the line today?
She's at work today, Your Honor.
Very good. Thank you. And just see if Joy Thomas, are you on the line, Ms. Thomas? Okay. And
this is a simple motion, Your Honor. This is kind of a long case. So the GAO was discharged quite a while ago. We're going back to trial. We just want an update. I think it would behoove Ms. Thomas as well, just to have an updated GAO report. But I'm sure Ms. Smith would like to get paid for that, considering the sheer amount of hours that she had put into this case before. It's years in the making.
Okay. Yeah. And yeah, that's why we're here, is a motion to reappoint guardian ad litem for the children. And I guess my one main question I wanted to touch base with Ms. Winkles is the trial. That the trial is set currently for the week of September 4th, right?
That's correct, Your Honor. And we're just looking for just a mini update report. I think Ms. Smith could get it in. I think we talked before, she could get it in a couple of weeks.
Oh, okay. Ms. Smith, do you think that's a feasible possibility?
Yes, Your Honor. I have been actually tracking this case pretty regularly between the parties as it's evolved. So I'm still pretty familiar with the specifics, and I'm able to get that report in shortly.
Okay, well, if that sounds great, that was my biggest concern. I didn't want this to cause us to lose a trial date. So, but if it's not going to do that, then let's, by all means, I'll make that reappointment of Miss Mallory Smith as guardian ad litem to give an update in preparation for the trial. I think that's well taken. So, Ms. Winkles, would you be in a position to prepare that?
I will, Your Honor. I'll prepare it. I'll send it around to the parties and to Your Honor as well.
Thank you. And Ms. Smith, are there any particular provisions that you think would be important or included within that order from your vantage point?
As
far as payment and the like, and
I don't have a preference, Your Honor.
Okay.
And considering the sheer amount of unpaid time she's done, I was just going to put it for the full amount. I believe it's $14.85, $67.50 an hour. Am I right? It changes a lot.
Yes, Your Honor. Yes, Ms. Winkles.
Yep, that sounds great. I think that's based on the $67.50 per hour or whatever
that's correct.
Okay, sounds good. All right, thank you for preparing that. And Ms. Winkles, should we set it for a presentation date, or is that something that I could just chalk off?
I think you can just chalk off. I know Ms. Thomas will want it as well. I think everybody will.
Okay, all right, great. Thank you. We'll look for that, receiving that by early next week. Lee. Mr. Lee is present. Can you hear me, Mr. Lee?
Morning, Your Honor. Yes.
All right, very good. Welcome to you. He represents Catherine Martin. And is Ms. Martin, are you on the line today? Catherine?
Yes,
Martin?
I am, Your Honor. I'm right here.
Okay, welcome to you.
Thank you.
Miss Tina Day is the guardian ad litem. I see her. And can you hear my voice?
Yes, I can.
Okay, wonderful. And we have, let's see. And then Chase, is it Schaub or Schaub?
Chase Schaub, he's having technical difficulties.
Okay, and is it something? Go ahead.
Yeah, he's I'm not sure. He just texted me and said he's trying to get on to the meeting, to the court case, but he's having difficulties.
Do you know?
He's still trying.
Okay. Do you know if he has just a link, or would he want to try using a phone number to dial in? Sometimes that's a more reliable way.
So he said that he's getting a message saying that it hasn't started yet.
Yeah.
He may be still in the waiting room, depending on what number he's calling in on.
Oh, yeah. I'm checking, at least on my waiting room. I don't see anybody there. Although he just popped up. Okay, let's and we've introduced Mr. Lee representing Ms. Martin, Ms. Day as the guardian ad litem, and we've spoken briefly with Michelle Lieber, who indicated that Chase Schaub, if I hope I got that last name correct, is here, and looks like he is connecting via audio. So, Mr. Schaub, can you hear me? Okay.
Yes, I can hear you.
Great, and can you please help? Will you pronounce your last name for me?
Schaub, Schaupp.
Schaub, perfect. Thank you. Well, welcome to everybody. We're here on a motion for show cause related to the guardianship. So I know that in the past there was an order that indicated supervised visits Saturday 10 a.m. to 2 p.m. for Mr. Schaub. And so I'll hear, and I usually note the moving party, and I just felt to do that to tee things off. So.
No, and Your Honor, if I may, there's on this one today, there's no failure of to note anything, because really we're here because the guardian ad litem has a report to present. So I'm going to at least defer to the guardian ad litem to begin the proceedings today.
Okay, I appreciate that, Mr. Lee. Thank you. Ms. Day, do you want to take the lead and give an update or give your input?
Yes, Your Honor. I did finish my report and file it yesterday. I provided a courtesy copy. I don't know if that made its way to your desk or not.
This morning. Got it.
Good. The short version is, at least in the emergency, the father has already signed his agreement and he remains in agreement. Mother is not 100% in agreement, but she does agree that Kathleen should stay with the petitioner for at least the next 60 to 90 days, as she's in the process of obtaining her own housing and hopes to be in a place where she would be stable and able to care for Kathleen. So the short version is that it's my recommendation that Kathleen remain with the petitioner, continue to get the services, and that the parents continue to work through their processes, mom primarily in obtaining safe and stable housing and for the petitioner to continue to provide the services that the child needs. This is a child who is significantly delayed and has some very high needs, and she's getting extensive services in the Tacoma area currently. The one change I think that I would be requesting would be to make some adjustments to the visitation, to put some of the responsibility to be shared by the parents. Currently, the petitioner is providing all the transportation during the weekend, and it would be, I think, appropriate for the parents to at least split that transportation or provide one way.
Okay, and then so the visitations are occurring so your suggestion is to pick up in Tacoma, the parents do the pickup in Tacoma, and then petitioner would go back down to Longview to pick them up.
Yes, or they could share it halfway. I think there's been some discussion about meeting in the middle, which I think is fine. They are currently having every weekend. I had recommended that we do 1st, 2nd, 4th, and 5th to allow one weekend with the petitioner, that the child doesn't have to travel such a distance. And I haven't heard any response to that, and that the parents continue to have phone or video contact as frequently as Kathleen is able to participate.
Okay. All right. Thank you. Let me double check with the parties. First off, did everybody receive a copy of Ms. Day's report? It looks like it was filed yesterday, so fairly short notice. Mr. Lee, did you receive a copy?
I did, Your Honor.
Okay. And Mr. Shop, have you seen a copy of that order or pardon me, a report?
Yes, I have.
Okay. And Ms. Martin, have you seen that report?
Yes, I received it by email this morning and I have overlooked it.
Okay, great. And then Ms. Leeper, have you seen that?
Yes, Your Honor. Thank you.
Okay, great. Good. Well, I appreciate that. So let me hear from Mr. Lee.
Yeah, thank you, Your Honor. I haven't had time to consult with my client yet about the report specifically. So what I would probably ask at this point, Ms. Martin, is there anything that you would like to respond with to the court about the guardian ad litem's report? Or do you need a sidebar with me alternatively to discuss?
I'd like to have a sidebar with you, please, for a moment.
Okay, Your Honor, would that be acceptable?
Yeah, let me touch base with the parties. So I'm just taking a look at we have one more case on, which I think you all could chat for a bit and then we can address that other case and then we'll wait to come back. Or if there needs to be a little more time to digest things, we could come back next week and address the matter, having the benefit of reading the report maybe a little more carefully than the quick one through that we gave it. So my preference, since I just barely glanced over the summary section of it, since I haven't read all of it, would be to set it over 1 week and allow a less hurried or an unhurried approach to it. So let me just see, as far as, is that okay? Is that okay?
Your Honor, I'm very amenable to a continuance.
Okay. All right, Ms. Day, any concerns with that?
No, I have no concerns with that. I think that's more than appropriate. And, I think it's difficult when things are rushed like they are in the guardianship. So I think that makes good sense.
Ms. Martin, any concerns if we set it over 1 week? That'll give you an unhurried time to speak with your attorney.
My only concern is I do have class from 9 to 10:30, so I would be a few minutes late getting to the meeting.
Okay. Yeah. Usually that's not an issue. So I think we can accommodate that. If you're not here, then your attorney could say, hey, she's on her way, and then we can make arrangements for that.
All right, I would appreciate that. Thank you.
Let's check with Mr. Shop. Mr. Shop, there's a recommendation at least to set the case over 1 week so we can all take a look at the report and consider it a little more in depth and then come back and then speak about it and maybe possibly make some changes.
Yeah, I wouldn't have a problem with that, especially since today I am probably going to end up going clothes shopping for my daughter anyway, too.
Okay. All right.
So if we need to set it over a week to talk about it, then I don't have an issue. It's less stress on me too, because I don't think anybody wants to speak here either.
Okay. All right. Ms. Leeper, are you available next week, August 10th, 10:30?
Yes, Your Honor. The only thing with me is I'm leaving work to come to court, and it's like, if we can do it like as soon as possible on the docket, would that be an issue? If we were like 1st or 2nd or 3rd, would that be a possibility?
Yeah, it's definitely a possibility. There's a lot of chefs in the kitchen when we come to a docket.
Right.
What I would encourage you is when the docket starts, you might just hop right in and maybe send a quick chat note to the judge, because it may or may not be me next time. speak up and say, hey, I would really appreciate if we could call this case early in the docket, if not first.
Okay.
Okay. All right. Well, I
Thank you,
appreciate it.
Your Honor. Mhm.
All right. I appreciate everybody's flexibility. Thanks for your input. We'll set this matter over 1 week to August 10th at 10:30, and we'll review more fully. Oh, one moment. So before we set it over to the 10th at 10:30, pardon me, the clerk raised an issue of whether I'm signing an extension of the temporary, immediate, emergency. I get the verbiage mixed up, of guardianship until next week. Are there any concerns related to that from any of the parties?
No, Your Honor.
No, Your Honor.
None here.
None here.
Okay. All right. So yes, thank you. Madam Clerk, I'll be signing that continuation until next week, and then we will gather again next week and we'll discuss things. Here we should have, thank you for your patience, and we'll see. Let's see what parties we have here. We have Ms. Jennifer Powers. You're present. Can you hear me, Ms. Powers? Okay.
Yep.
Great. And then we have Justin Homer and Jennifer Peterson. Can you hear me okay?
Yes.
Okay, wonderful, good. And then we also, let's see, there's Ms. Powers. There you are, Ms. Powers. Ms. Powers is here representing the state. So we're here on a couple of matters. We were here earlier related to child support concerns brought by the state. And then there was a brief discussion on that when we were here last. And so the state is still seeking that. So I'll just, maybe we could start off hearing from Ms. Powers and then go from there.
Thank you, Your Honor. We were here on July 20th, and the court set over to today so that the parents could provide additional information to the court. The parents did provide some sealed financial documents along with some declarations. I have reviewed everything that they've provided and did not find it particularly helpful in terms of giving us a better idea of what the financial position is of the parents. They provided profit and loss statements, which they had prepared themselves. They provided a cover sheet indicating that they filed taxes in 2020 and 2021, but they did not actually file their tax returns. So my reading of the information, it looks like they have not completed their 2022 profit and loss statements, but the way it was submitted showed significant profits, although they indicate they hadn't finished including their expenses. After reviewing everything, I would stick with the worksheets and order as I originally proposed. For the mother's income, we imputed her at her average hourly wage earned over the last 3 years of employment security data. That at least gives us a solid base to know what she's capable of earning. So I imputed her at 35 hours per week, $19.35 an hour. The father has no employment security history as he's been self-employed for a significant period of time. I would still ask that we put him in net median income. The parents have 2 other kids living in their home, so I've included a whole family deviation. I'm asking for a transfer payment from the father of $486 a month and a transfer payment from the mother of $281 per month.
I have no income. Zero.
Can I respond to what she spoke on?
Yeah, absolutely. Go ahead.
So the reason I submitted those profit and loss statements, which I do prepare by myself, if you look at year over year from 2021 to 2022, there was a substantial loss of around $140,000. I don't have the exact figure in front of me, but that is the reason I submitted that. We file an extension for our taxes every year, so our taxes won't be done until late September, which is the reason 2022 is not filed. We have to do that because we're an online business and we still have products shipping out throughout the year, so we can't file it by the middle of April. My wife has worked previously back in 2019, around when COVID hit. She started working for the business. The business did a big dive, so she's here helping me. She can't go get a job because we're trying to keep this business afloat. So I don't know where we're coming up with these numbers. I submitted those forms to show all that, prove all that. That's all I can prove is what I've submitted. So I don't.
So thank you. I appreciate that. Let me just ask you, looking at those profit and loss statements that you submitted.
Yes.
So I kind of just need a little bit of explanation looking at those. And so there's 3 years. We've got 2020, 2021, 2022. So when I was looking at those, I didn't get into the nitty gritty of any of it really. But when I'm looking at the kind of the net total sales in 2020, It looks like it was 345,000 and total expenses were 308. So profit was 36,000.
Correct.
Okay. And then looking at 2021, total sales were 383,000. Expenses were 334 for a net of 49,000.
Correct.
And then in 2022, total sales were 247,000. Expenses were 39,000 with profits of 207,000. So I see what you're saying about as far as a dip in revenue or income or sales, I guess sales is a better term, from 350 higher than that, and then drop down to 245. But then my question, I guess, is that last figure of total expenses of 2022 were exceptionally low, and the profits were increased dramatically.
Because the expenses haven't been input yet. If you look at if you actually look through this, it shows zeros in the spots that are really critical, like our supplies, our property payment, inventory invoices, all those things that are huge numbers.
Okay,
haven't been input yet, and I just haven't input them yet because we don't do our taxes until, like I say, another about a month and a half is when I really start preparing everything. So.
Okay, I see that. That helps. Thank you for that clarification.
Sure.
Then, did you have any? You heard Ms. Amy Powers mention that she's proposing a whole family deviation, which basically gives credit or a lightening of the load, if you will, for the other two children that are within the home. Do you have any questions on that?
No, I understand how that works.
Okay. All right. Very good.
And I don't know if you guys, the adoption support issue we brought up too is, we were receiving, what was it, $900? $900 from the state. And now you guys are proposing that we pay 700 and I don't have the number. Let's see, 767. So, I mean, it's just a huge swing. And
what's happened to the adoption support? What happens? Go ahead. So you stopped receiving it back in end of March, right?
Yeah, when Caden ran away, they stopped it immediately.
Okay, and is that being redirected to another party?
It's out of our hands.
They just said we're stopping it, and that's all the last we heard.
Okay. And when was the adoption finalized?
In 2013
13 years ago.
10.
He was 3 when we adopted him.
13 years ago. Okay. All right, thank you. Let me touch base with Ms. Jennifer Powers. Do you have any input?
So I seeked out TANF support because Caden did not run away. He was kicked out. I have text messages to show that. This is the second child that they've adopted that I've taken in. Caden didn't have anywhere else to go. I called CPS to see if they could find placement. The only option for Caden at the time and still currently was a group home. He's special needs. He has a lot to learn. He would not succeed in a group home. So we are just trying to do what we think is best for him. And he is in counseling 3 days a week, which costs a lot of money. He also came with just the clothes on his back and nothing else. So we had to immediately buy him school clothes, school supplies, everything else. So I seeked out TANF to help alleviate some of the cost of taking on a child that we did not know we were going to be taking on. As far as the rest of it goes, it's just, just trying to get help with taking care of a child that we did not anticipate having. So we're just doing the best that we can for him. And we, as far as the adoption support goes, I mean, my understanding of it is that it stops when you no longer have the child in your care. And I can't get adoption support because we're not adopting him. We're just guardians. And we'll have him until he's capable of taking care of himself, which will be, after 18, because he'll not graduate high school until he's almost 19. So
Caden's 16 now, is that right?
He's currently 16.
16. Okay. All right. Thank you, Ms. Jennifer Powers. Let me check with Mr. Homer, Ms. Peterson, related to there is, I read something about the consent, that when you signed off on the consent, you didn't see anything related to financial implications. So the petition, I think, was filed by Ms. Jennifer Powers, and she indicated, at least at that time, she wasn't seeking any support, financial support, and that was part of the reason why you entered into the consent. Do I get that right?
Correct.
Okay. And then now the state on its behalf has brought that motion. So I think the consent is still valid because the party or the representation from the petitioning party, Ms. Jennifer Powers, was that she wasn't seeking and she's not, and now it's the state that's seeking, and that doesn't necessarily make it easier or better for you all, but that's at least my understanding of your consent argument and at least my view of how that's worked out. Any comments on the consent issue?
No, I just don't understand if the state was paying us adoption support, why isn't the state paying the TANF as well? I mean, it just doesn't make sense in our, I mean,
It's basically our family has endured nothing but torture and torment from these adopted boys that we've gone through. Our children are traumatized. I am significantly traumatized to the point I have PTSD. I have flashbacks. I'm not doing well. I have no income. You guys are putting us into a financial hardship where we're going to have to go on welfare to afford our own children and our own home. This makes no sense to me. Caden is disrespectful, out of control. I have 75 holes in my wall that I'm still trying to fix from him. I have been physically assaulted, mentally abused. My daughters have been mentally abused. Our family needs to be done. We cannot afford to continue supporting this behavior, this dysfunction. It's disgusting. I'm sorry to go off, but I'm just can't handle it.
Okay. All right. Thank you. I appreciate that input. So here, Ms. Amy Powers, you've imputed Ms. Peterson at $19.35 an hour over, and you said 30 hours a week, correct?
35 hours per week. Our office treats 35 as full-time instead of 40.
Well, I'm working 60 and I don't get paid a dime.
Right.
I'm killing myself to keep our family afloat. I'm sorry. I need to step away.
That's okay. That's okay. All right. And then you're imputing the net median income to Mr. Homer, correct?
That is correct.
And your child support worksheets here, that sets it at roughly $5,100 per month. That's a net amount, correct?
That's correct.
Okay. And then Ms. Amy Powers, with regard to the profit and loss statements, you saw that the net operating profit was, $36,000, $49,000 per year, roughly in those past couple of years. And it's not a really complete information. How does that impact your decision to set it at net versus those maybe reduced figures based on the profit and loss?
Well, I looked at the fact that the total net profit has increased. It increased between 2020 and 2021. I also noted that this business is run out of the party's home. They did provide information of large debts that they're paying, but they did not provide enough information for us to tell what living expenses are being paid as part of the business expenses. I did see information that had been reported with their state medical that showed a higher income, but I didn't have a strong basis to know where that came from, so I did not use that as a basis. But looking at the net profit and loss statements, the income was going up. There's a lot of expenses. Some of those expenses may be part of their living expenses. And so that's why I chose to stick with the net median rather than pick a different number.
Okay, thank you. Let me ask Mr. Homer. Ms. Amy Powers raises that issue of with a self-employment situation, and running a business out of the home, there's sometimes a mix of expenses that are cross lines between business and home. When you file your taxes, is that presented in a kind of a clear fashion? 60% is of household expenses are for the family, 40% is to the home. Is that in your past taxes?
It's not that clear. It's a sole proprietor business. So, I mean, it's all under my social security number. It's my credit cards, everything are under my social security number. There's nothing separated. So, I mean, to be honest with you, I really don't know what I make a year. I just know that the last couple of years is, I've been having to run up credit cards. I've been taking, capital loans. Like my wife said, it's this, any other expenses at this point is just going to drive us into a hardship. And I'm not saying that because I don't want to pay child support. I'm saying that because that's the facts. I mean, it is what it is. So, I mean, I know you guys are looking at a snapshot of incomplete records, but it is what it is. I just look at my two daughters that are, how do we go buy school clothes for them? Do we just go tell my 16-year-old she has to go get a job to buy school clothes now? It's just frustrating. So, yeah, I apologize that, the taxes aren't more complete than they are, but if I had another month and a half to finish this, you would see that it's a net operating loss, not a profit. So,
We're 2022.
Correct. And 23. We're trending the same numbers as 2022.
Okay. Let me ask Ms. Amy Powers, as far as there's some indication that the taxes are filed in September. Mr. Homer indicates, maybe a 6-week time frame to get those submitted, and that may provide a more accurate picture of the finances. And so I want to get your take on that as far as a potential set over to see that. And I also want to hear from Ms. Jennifer Powers and get her input, because I'm thinking maybe some amount of support now, and then with the opportunity to revisit it when we have better numbers. Ms. Amy Powers.
I would not be opposed to the court changing these child support orders to temporary orders if you want to set a review out. But I would note for the court that the parents have filed their taxes the last 2 years and did not provide those either, even though those have already been filed. And that would have potentially provided some better information. So I would still ask that some sort of order be entered today.
And you're asking for an effective date of when?
July 1st, as the child began receiving TANF as of June 30th.
Okay, thank you. All right, Ms. Jennifer Powers, do you have any comments on that issue?
I mean, I'd like to say that I understand this is difficult for both sides, but I'd like to see that my side of this is also seen by all parties. I had a child show up at my door on March 22nd that needed a place to stay, that did not have a great option through CPS and could not go home. And I had to go out immediately and use money that I did not have and take away from my own children to buy him school clothes, shoes, school supplies, everything, because I asked that all that be given to me and it was not. And this has already happened with a previous child as well, exact same situation where I was not given anything. It's hard for me to sit here and listen to all of this because I live in an 800 square foot house. I don't have a glorious life. We're just trying to do what is right by this child that just needs someone to take him to counseling 3 days a week and get him on the right path. He's now drug free. And he is really trying hard to do what he's supposed to be doing, and he's learning a lot. And, I have to go out and buy him school supplies. I did not choose to adopt him when he was 3. I didn't even choose for him to show up at my doorstep and start living with us, but I'm doing what I feel is right by the child because I don't think that a group home is the right solution for this child. I don't think it's the right solution for any child, don't get me wrong, but he has special needs and is on an IEP through school, and he needs a lot of guidance, and it's not going to happen in a group home where he doesn't have an individual person caring for him and showing him how to do everything. So, it's not that I'm trying to be rude or hurtful or anything else. I'm just trying to do what's right by the kid. And I think we all know that it costs a lot more than $417 a month to feed a 16-year-old boy that's growing, let alone clothe him and house him and everything else. And that's not including him wanting to play any sports or do anything else, or me driving him to and from counseling 3 days a week. So, I just, ask that my side be seen as well. It's not, I didn't choose this. My family didn't choose this, but we're making the best of it and we're doing what we can for him.
Can I just say, actually,
yeah, go ahead.
It was a choice. Caden chose to run away. Caden chose to go to their house because they have told all 3 of the boys that we have adopted that they're welcome at their home anytime, for any reason, under any circumstances. That's part of the problem that has occurred in our home, is whenever we try to set boundaries, guidance, examples, put an end to the drug abuse, the physical abuse, the mental abuse, they escape. And then we're made out to be villains when we're not.
The consequences are they can just run away.
Exactly. And Jennifer Powers, you and your husband, Kyle, I think it's wonderful that you've taken him in, but that was your choice, 100%. That is what I'm going to say on that. Caden is.
All right. Well, I appreciate the input from all parties. Obviously, a super hard, emotionally difficult at best situation. Lots of varying inputs and lots of concerns and heartache and difficulties. So we're here on the issue of maybe the more sterile, but nonetheless still important issue of financial support related to Caden. Here's my take on this is that, one, the adoption support, it's kind of cruel irony that the adoption support's there and then it's gone. And then there's a request for child support. So when I look at the numbers, you know, it's a squishy picture, if you will, as far as finances. We have a profit and loss statement for 2022 that's incomplete. We don't know, you know, a lot of the dollar figures. We'll probably know that soon and have a better idea on that. Obviously, taking a look at tax years 2021 and 22 will help refine, put a finer point on the calculations. We have what we have at this point. TANF started being paid out at the end of June. So I think I need to make a decision today, and it can be reviewed later on once we have a finer picture, or a more acute or greater clarity picture. So as far as the net median income for self-employment for Mr. Homer, I think that's well taken. Self-employment is always very difficult to tease out the numbers and the mixing that's almost inevitably there. There's no indication of, you know, I'm not suggesting any nefarious attempt to hide or anything like that. It's just there's a mixing that happens with self-employment, and it's difficult to tease out. What I think is a little more challenging for me is that there's an indication that that Ms. Peterson has been working for the family business and caring for the children, and not to say that dad isn't doing the same thing, but she's working for free basically, and that's what family businesses do. They chip in and make things happen. So I'm not going to impute her. I'm going to put her net income as being subsumed by the income of the father. So it's a joint activity, and that joint effort goes into producing the single income of the net median income of 5109. So that's what I'm going to set the net income at and base the child support on that. That'll be effective July 1. And then once we have, I don't know if it would be proper at this point to set a hearing once the taxes have been filed. If Mr. Homer, Ms. Peterson, if there's a firm date that you feel that you'll be filing that, if there's a date that you need to file it by, then maybe we could set it a week or two after that to review things.
It's mid-October, but I usually like to have it done by the end of September so that we can renew our insurance, because the insurance wants to, you know, the state insurance wants to see what our income is each year. So I usually have it done by the end of September. So I would say October 1 would be the earliest date.
Okay. All right. Ms. Amy Powers?
I'm trying to figure out how to put this into an order. So I want to clarify. You have put the father at net median and you've put the mother at 0. Is that essentially what you've done?
Yeah, that's a good question, and I haven't thought through it all. My thought is this: is that it sounds like for for an extended period of time, the family has combined efforts to produce income, and there's not a separate source of income, and nor is there really a viable option to do so, because those efforts are needed to keep the business running and up and going. So I don't know if that means that she's set it at 0, or if Mr. Homer set at 2,500, she set at 2,500 or 26, 2,550, 2,550. I'm not exactly sure. It seems if that's the route we go, that seems fair, because both parties are expending a lot of energy and time.
What I'm concerned about is 2,500 is about a minimum wage order per parent, and the information does not show that these parties are only capable of earning minimum wage, and the state is providing for this child, even though they have the legal obligation to do it. So I would just ask the court to keep that in mind as you're making the ruling.
Yeah. So let me ask. So is it more kind of just? I'm not sure if it's a kind of a general disagreement with the court order, or how to implement the court's order.
I guess a little bit of both.
Okay.
I'm concerned if the court is essentially setting both parents at full-time minimum wage, when that's usually reserved for people who either have a history of earning minimum wage or no employment history. I suppose maybe that's appropriate for the father, since we don't have other information, but we do have information for the mother that she's earned more than that. And my argument would be if the business is failing so bad that we're not even bringing in as much as minimum wage, it doesn't make sense to me that we would, it would seem that they're underemployed. Well, the state is bearing that cost. But if the court is going to keep this as their order, I need more direction on what incomes do I put in each party's column on the worksheets, and how to ferret that out.
Okay. Let me ask you a point of clarification. So if father set at 5109 per month and mom set it at 0, or on the alternative 2550 each, that doesn't change the bottom line. Doesn't matter. It's going to go through the same funnel and it's going to have the same dollar amount at the end
Correct.
as far as support. Okay.
Yeah, it should. If mom's at zero, it would put her at $50 a month, but absent that, it's going to be the same obligation.
Gotcha. Okay. All right. So just addressing the well-taken argument related to minimum wage. Self-employment is a different animal. I grew up in a home where my dad was self-employed. There were months and years that were amazing. And I remember one time sitting at the dinner table where we sat down and dad said, well, we're not going to be able to do this. We can't do that. We've got to turn this back in. And things were exceptionally tight. So there's an ebb and flow in the business cycle. And sometimes that's out of a person's control. There may be new competitors on the market. There may be national funding. There's a lot of things that could go into that. And that's kind of the basis of my rationale with family businesses, is that there's this natural roller coaster of income. Sometimes it may be fairly steady, and there has been a steady increase, at least from year over year of 20 to 21, but 22, at least from the preliminary figures, are showing that there's been a dramatic, percentage wise, a little less than a third of revenue decrease. And usually the costs don't decrease correspondingly. Costs generally are fairly stable, and you can cut. Yes. So that's part of my rationale. The other part of my rationale is that even if Ms. Peterson were to go out and get a job, I'm not sure what type of job she would get and how that would affect the income that's being produced through her efforts and labors combined with the father's to produce the income that is coming in. So it may have the impact if she gets a job there, it may be a negative impact on the overall financial picture. That's my thinking. So I'll set the mother's income at $0, and that'll put the support at $50 a month. And I'll set the father's at $51.09. And I'm not exactly sure where that puts him at. It may be around the 486 level, but may be slightly different. I think it's a 486.
I will rerun the numbers. It'll decrease since we're taking mom's income out of the worksheets. So do you want to set this over 2 weeks for presentation? Are you going to be continuing to do this docket?
My understanding is that I'm kind of filling in.
Okay.
So it's unlikely that I would continue on a regular basis. So we may look at a Friday morning at 8:45. That's my regular presentation docket.
Okay, should we set it then to August 18th, and I will rerun the worksheets and orders and get them out to the parties.
Okay, so that's Friday the 18th. So what we're talking about, Ms. Amy Powers is suggesting, is that she's going to rework the child support worksheets and the order to reflect the court's order today related to incomes and corresponding child support, and that she would present that to all parties prior to the 18th. And on the 18th, if there's any concerns that what she's produced, if that's contrary or not in accord with what the court's ordered today, then all parties could speak up and share their concerns and say, hey, she got it wrong, or hey, she got it right. How does that work for Mr. Homer and Ms. Peterson?
Sounds fair.
Okay. All right. And then Ms. Jennifer Powers, are you available on the 18th at 8:45?
Give me 1 second again.
Sure. I missed that. Could you repeat that?
On the 18th, would that be a virtual again?
Yes.
Zoom?
Yes.
Okay. And can you do that on a cell phone?
Yeah, you can dial in with a cell phone. Yep.
Okay, then yes, I can be available on the 18th at 9:30.
It would be at 8:45.
8:45. Okay, got it.
Okay. All right. So Ms. Amy Powers will get those orders out, distributed to the parties so you can take a look at them prior to the hearing. We'll be here on the 18th. If the parties agree and that you agree that what she's prepared is an accurate reflection of what the court ordered today, you can simply sign off on it. Then it'll be submitted to the court and it'll be signed off. If there's disagreement, certainly we'll be here on the 18th at 8:45 to discuss that.